question even more, but given the fact that it's the judge's determination when that officer can go in, it really is context dependent on the facts.
Thank you very much,
You're welcome.
Ms. Jackson. Mr. Gallegos.
No, a patient should not have to give up their confidentiality. 215, when I took office, 215 had recently passed. We passed prosecution guidelines, and in those guidelines, that was strictly written out that patient-physician privilege was not an issue for us. The question is whether there was a recommendation, and if so, whether that was within the parameters of that recommendation. 215, medical marijuana, the Compassionate Use Act, is a very difficult area in the law for law enforcement, the prosecution's office, and the community, because there is not much, if any, guidance. Certainly the Kelly decision that recently came down took away any guidance that we had from 420 and 215 that allowed our local legislators or supervisors to pass an ordinance which gave some definition as to how much someone could possess and cultivate. So we are stumbling along until our legislatures or the people of the state of California comes up with an appropriate way to get rid of the gray area. And until then, law enforcement, my office, are doing their best to try to balance these competing interests of enforcing the law, prosecuting those people that seek to abuse the law, and not prosecute people that haven't. And it is a labyrinth. So we understand it's not a matter of law enforcement enforcing 215, it's law enforcement respecting 215. We understand it is the law of the state of California, and it's the right of people to possess. Making sure that it is enforced and respected, as well as all our other criminal laws associated with marijuana, is the difficult part.
Thank you, Mr. Gallegos. Ms. Bryson.
I don't know if this was part of the question, but I heard when they talked about privacy rights, I heard perhaps the issue of code enforcement and how that's been used to get on people's property, to get probable cause, to then go and use that to get search warrants, to then have people's property invaded. Amen, sister. I hear you. One of the things that's so great about our county is the rural lifestyle. We have a rural lifestyle that is privacy. And what's happening in the area of code enforcement, or was happening, was the armed people coming onto people's property allegedly to make sure codes were being enforced, but what it ended up being was a way of getting into people's property for the purposes of searching them. I'm against that misuse of power. I have clients right now. Judges will sign any search warrant that's put in front of them so long as it has certain basic things on it. And they don't second guess the officer who puts it in front of them. Right now I have clients that Mr. Gallegos' office has filed complaints against that have been under the 215 limit. When the evidence is seized, there's no cash. There's no evidence of pay-and-o, which is a record of having sold and received money for sales. No guns on the premises. 215s in evidence, and yet they're still having to pay me to represent them in court. When we talk about the labyrinth and the gray areas, it's pretty black to me. They're being offered prison time, Mr. Gallegos. So what I want to know is what you're saying is all nice and good, but what's the reality in the courtrooms, which is what I deal with each day, is a whole other matter. Whole different matter.
Thank you, Ms. Bryson. Mr. Hagan.
Well, when I heard the question as to privacy rights under Proposition 215, I was wondering what it was, and what my mind went to first was the idea that perhaps a person has to give up some type of their medical condition or something of the nature from the doctor's records in order to get a recommendation, and that's not the case. So perhaps it was the code enforcement issue, I'm not sure, I couldn't tell from the question. In any event, you clearly don't have to give up any of your privacy rights in order to get a 215 card. What's happened with the code enforcement issue in Humboldt County is, I think Ms. Bryson touched a raw nerve there, and there was clearly some degree of overstepping there where code enforcement people were using peace officers, not just inspection warrants, which are allowed under code enforcement generally, but search warrants, which are very different. And as to search warrants, that's in the U.S. Constitution. It must be signed by a neutral magistrate based upon probable cause. And the magistrate doesn't just sign anything that's put in front of him or her. The magistrate is very much charged with looking at the statement of facts and statement of probable cause that's in the search warrant to see if there is probable cause to issue the search warrant. Once that's done, the police officers can go in and execute the search warrant, and then as the other part of the question, the person is let go after the search warrant is done. The police are under no obligation whatsoever to arrest somebody simply because they execute a search warrant. Sometimes they do, and sometimes they don't, and that's completely fact dependent. So to try to address the question as to why someone would have a search warrant executed on them for Prop 215 and then be let go afterward, that would be up to the individual police. And usually it's whether or not this person constitutes some type of an ongoing threat such that the person should be arrested, which is also based on probable cause under the facts that the police officer has in front of them, or not. If the person has committed the crime and the police officer thinks it can be proven in the law, in the courts by filing a report and sending it to the DA and charges being made, that doesn't necessarily mean that the police officer has any obligation to arrest someone pursuant to a search warrant. The two things are very separate.
Thank you, Mr. Hagan. Does anybody wish to make a response?
Yes.
Please.
First of all, I will try to be very brief and to the point. I expressly disagree with one of the candidates' assertions that our judges are simply rubber stamps. They are not. No judge in the 20 years of practice that I have met would just simply rubber stamp search warrant, and all of the judges that I have worked under and appeared in this county, none of them could be legitimately referred to as a rubber stamp. However, I will say, with respect to another point in that question, that unfortunately 215 is very poorly worded, and it has brought with it a whole host of problems. I recognize that 215 was passed by initiative. It is the law of the land. It allows medical marijuana. It does not allow commercial and growing, and because of the ambiguity in the law, it's left a lot of people struggling with how to enforce it. Instead of having something clear, they have been left to trying to make policy, and we've gotten into a lot of trouble in this county and other counties because of that. It would be my hope that the people, through the initiative process, because the legislature cannot do this, it would be my hope that the people would address this one way or the other in order to give our law enforcement some guidelines and give our citizens here some solace in knowing what is going to be completely protected and what is not. Because right now, there is that ambiguity, and until that's done, we'll continue to be at an impasse because of it.
Thank you, Ms. Jackson.
Thank you.
May I just respond?
Please.
I don't want to spend too much time on this, but I want to explain something real quickly. We are not sending people to prison for medical marijuana. Even if that were my desire, which it's not, that person gets sentenced by a judge. I do not decide sentences. Wouldn't happen with a judge. Our judges in Humboldt County, we are blessed with very good judges. Just this week, a warrant was set aside from an affidavit after a hearing on it. If defendants question the merit of the probable cause statement that initiated the warrant, there is adequate protections and a motion to traverse the warrant. And an independent party is looking. I don't want to get too much into the legal aspects, but the checks and balances we discussed earlier are in place and well in Humboldt County. And even if I were, which I'm not inclined to send someone with medical marijuana to prison, there's not a court in Humboldt County that would comply with that.
Thank you, Mr. Higgins. Does anybody else wish to respond?
I think I better. First of all, obviously the DA isn't sending anyone to prison, but they're offering prison time to me, which is an indication that they think that it warrants prison time. As far as what Ms. Jackson said, I wasn't talking about rubber stamping. I'm talking